Hi, Attorney Andrew Bethel. As an estate planning attorney, a big issue in the industry is that of trustee succession. What happens when a trustee resigns, is removed, or dies? To contextualize, a trustee is an extremely important position in a trust, as if you liken the trust to a car, the trustee is the one who has the keys and drives the car to begin with. Without a trustee at the wheel, the trust can't fulfill its function to hold and pass on assets. Today we'll be talking about trustee succession and what happens when there is a vacancy in the office of the trustee. But first, be sure to like the video, subscribe, and ring the bell to stay up to date. Also, leave a comment below if you have any questions or have a topic you wish for us to cover. But as always, thank you very much for watching. As mentioned, there are a few reasons why there might be a vacancy in the office of the trustee: removal, resignation, or death. But the baseline rule to always keep in mind is that the first thing you want to do is follow what the trust says. A well-drafted trust will provide instructions for what to do with a trustee vacancy. If the trust says the beneficiaries vote for a new trustee, then they have to vote. If the trust says the candidates need to arm wrestle for the position, then they better arm wrestle before someone runs off to a judge. But in all seriousness, trusts are often large documents because they are typically built to address any potential circumstances. For example, in our trusts, we'll first have the trustors, the people making the trust, pick people to be their successor trustees, the ones who step in and become trustee after they, usually the parent, passes away. Essentially, we create a line of succession based on who the trustors think would be the best fit for the role. Next, as a safety net, we say the former trustee can designate a new trustee unless the former trustee is being removed. We don't want them sabotaging the trust on their way out. Then we allow for a majority vote among the adult beneficiaries to decide who is the next trustee, before then allowing for a probate court to have the final say if all else fails, a power the court has regardless. However, if a trust doesn't say or it isn't clear, then we need to first reference California Probate Code section 15644, which in part holds that when a vacancy has occurred in the office of a trustee, the former trustee who holds property of the trust shall deliver the trust property to the successor trustee or a person appointed by a court to receive the property and remains responsible for the trust's property until it is delivered. What that means is whoever is holding or managing the trust property, usually the trustee who has resigned or was removed, must deliver the trust property to the new successor trustee and is on the hook for anything that happens to the property until that point. Now, that delivery can be changing title on a bank account, filing an affidavit with the county recorder, changing title to any real property to the new trustee's name, or even physically delivering goods such as personal items or keys to something like a safety deposit box or a house, what's called constructive delivery since you can't physically hand them over. This code section also references a possible avenue for selecting a new trustee in the event of a vacancy: court appointment. Where there is a vacancy and the trust does not have a listed mechanism for appointing or selecting a successor trustee, then a probate court always retains the authority to appoint a trustee if required, but we'll get into that a little more in a minute. Additionally, remember, until the property is delivered to the new trustee, whoever they are, the former trustee cannot just wash their hands of the matter. Until they deliver the trust property, that former trustee is responsible for the property as if they were continuing to be the trustee. If there is a house, it can't fall into disrepair or fall behind on bills. If there are investments, they need to be overseen. If there are personal items, they cannot be simply left to be stolen or maybe even broken. In fact, section 15644 continues on to say a trustee who has resigned or is removed has the powers reasonably necessary under the circumstances to preserve the trust property until it is delivered to the successor trustee and to perform actions necessary to complete the resigning or removed trustee's administration of the trust. Again, that means the trustee who is on their way out the door has to keep the ship or car right until the new trustee takes over. Until that delivery of the assets takes place, the former trustee retains the power to do only what is required to safeguard the assets, which of course is going to be situation dependent. Most of the time it's going to be simply making sure that nothing happens to the house before they deliver the keys to the new trustee. Now let's get into some specifics for the different reasons vacancies occur, starting with the most common, death. That might sound strange, but the most common reason trustee succession is a concern is when the initial trustee has passed away. What I mean is that in the overwhelming majority of cases, when trustors initially create their trust, they put themselves as trustee, which makes sense since you don't want to give up control over your own stuff. At the creation phase, those trustors who also designate their successor trustees usually pick at least two, a successor and a backup. For example, mom creates a trust and is the trustee. She passes from old age, and her financially responsible child was designated in the trust as the first successor and stepped into their trustee role and begins managing mom's estate. Death is the most common reason for a change in trusteeship and doesn't carry any special rules aside from what we've already spoken about already. Go down the line of succession in the trust, follow what the trust says if you run out of names, and petition the court if neither of those options are available. Next, we have the resignation of a trustee, someone declaring that they no longer wish to be a trustee. However, as with removal of a trustee, which we'll discuss in a moment, the resigning trustee is still on the hook, so to speak. Their duties and obligations don't end the moment they resign. The new trustee has to have the trust property delivered to them and accept their position as the new trustee, as only then will the former trustee be relieved of their duties. Importantly, however, the former trustee is not relieved of any liability for the period they were in office as trustee, as we discussed previously under section 15.644. Quick note, the method by which a trustee resigns is typically by them executing a simple writing saying they are resigning as trustee and delivering such to either the next trustee or the next trustee and the beneficiaries. A notary is often recommended but not explicitly required. However, the new trustee must accept their position, typically with a simple writing that they accept the role and their signature should be notarized. The method by which a potential trustee declines to serve in the first place should also be by a signed writing, just like a resignation, but without the delivery and intermediate responsibilities, since a declining trustee was never actually the trustee. Lastly, we have removal of a trustee, which is a massive subject of its own right, but this video is already long, so we'll summarize it here and do a more in-depth discussion in a later video, so be sure you're subscribed for that. Generally, when we're talking about removal of a trustee, we are talking about forcing someone out of the trustee office via court removal and thus court involvement. To remove a trustee, the court requires there to be grounds for removal. Those can include, number one, a breach of trust by the trustee breaching or failing one of their duties. Number two, the trustee being insolvent or otherwise unfit to administer or substantially unable to manage the trust estate. Third, where the trustee is substantially unable to resist fraud or undue influence. Number four, failure or refusal to act, or where there are co-trustees, hostility or lack of cooperation among said co-trustees that impairs administration of the trust. Number five, where the trustee's compensation is excessive under the circumstances, which is, in essence, a breach of a trustee's duty of loyalty not to benefit to the detriment of the beneficiaries. Number six, where a trustee is someone in a position to have exercised undue influence or coercion, such as the drafter of the trust, or in the case where we see the most trouble, the caretaker of the trustor. This alone is a large subject and warrants its own video. And finally, number seven, for other good cause, which is a catch-all that grants the judge discretion to remove a trustee where they see it's warranted, but where the rationale doesn't fit into one of the categories I've mentioned already. Everything I've mentioned is spelled out in greater detail in California Probate Code section 15.642 if you'd like to read more. Again, this is a large subject, so we'll cover it in more detail in a later video, but to finish off removing a trustee, keep in mind that just like resigning trustee, the removed trustee is still on the hook until the delivery of the assets and acceptance of trusteeship has occurred with the new successor trustee. Being removed as a trustee is not an instant removal of one's duties as trustee and is never a removal of liability for one's actions during their tenure. Keep in mind, if you are aiming to remove a trustee, you must show cause, otherwise the court may find you operating in bad faith and hold you responsible for all the legal fees incurred as a result of the suit. That's your legal fees, the defending trustee's legal fees, any damages or expenses incurred by the trust as a result, and potentially the court filing fees. Trustee removal is not a small matter. All right, we've covered a lot, and this is only a summary. Just remember that when it comes to trustee succession, look at what the trust says first and follow what it says there. If all else fails, a court will have final say as to who will be the trustee. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.